The recent cases of Ranjani Srinivasan and Lekha Kordia, both students at Columbia University, have sent shockwaves through academic circles, raising concerns about the limits of free speech on campus and the precarious position of international students. Srinivasan, an Indian national pursuing a doctorate in urban planning, made the difficult decision to self-deport after her student visa was revoked due to her alleged support for Hamas, a designated terrorist organization. Kordia, a Palestinian student, faces imminent deportation after her visa expired, further complicated by her previous arrest for participating in pro-Hamas protests. These cases highlight a critical tension between national security concerns and the principles of free speech, particularly within the academic environment. While the U.S. government has a clear responsibility to protect its citizens from terrorism, the revocation of visas based on alleged political affiliations raises important questions about the boundaries of permissible speech, especially for international students who may be unfamiliar with the nuances of U.S. law. The chilling effect of these actions on academic freedom cannot be ignored, as students and faculty alike may hesitate to engage in open dialogue on sensitive topics for fear of repercussions. The situations faced by Srinivasan and Kordia serve as stark reminders of the vulnerability of international students navigating the complexities of U.S. immigration law. The potential for political speech, even if deemed controversial, to derail academic pursuits underscores the need for greater clarity and transparency in visa policies. Moreover, these cases highlight the importance of robust due process protections to ensure that accusations of material support for terrorism are subject to rigorous scrutiny and fair adjudication. The legal basis for the U.S. government's actions in cases like those of Srinivasan and Kordia lies in the Immigration and Nationality Act, which grants broad authority to deny or revoke visas for a variety of reasons, including national security concerns. Under the INA, individuals deemed inadmissible to the United States include those who have engaged in terrorist activities or provided material support to terrorist organizations, a broadly defined term that encompasses a wide range of actions. While the government's interest in preventing terrorism is undoubtedly legitimate, the application of these provisions in the context of free speech on campus raises concerns about overreach and the potential chilling of protected expression. The First Amendment to the U.S. Constitution guarantees the right to freedom of speech, even speech that some may find offensive or objectionable. However, this right is not absolute, and the government may place certain limitations on speech, particularly when it comes to national security. The challenge lies in striking a delicate balance between safeguarding national security and protecting the free exchange of ideas, a cornerstone of academic freedom. In cases involving alleged support for terrorist organizations, the government must demonstrate a clear and present danger posed by the individual's speech or activities. Mere association with or expression of sympathy for a designated terrorist group, without evidence of intent to engage in or support violence, should not be sufficient to justify visa revocation. The burden of proof rests on the government to provide concrete evidence of a genuine threat, rather than relying on vague allegations or guilt by association. The cases of Srinivasan and Kordia highlight the ongoing tension between protecting national security and upholding the principles of free speech, particularly within the academic environment. Universities have long been considered marketplaces of ideas, where diverse perspectives are encouraged and debated. This free exchange of ideas is essential for the advancement of knowledge and the development of critical thinking skills. However, the threat of terrorism poses unique challenges to this ideal, as the government grapples with how to safeguard national security without unduly infringing on fundamental freedoms. The government has a legitimate interest in preventing terrorism, and it is understandable that there would be concerns about individuals who express support for designated terrorist organizations. However, it is crucial to remember that the vast majority of students, including international students, come to the United States to pursue their education and contribute to society. Sweeping generalizations about entire groups of people based on their nationality or religion are not only unfair, but also counterproductive. They create an environment of fear and suspicion that undermines the very values that make the United States a beacon of freedom and opportunity. To strike a balance between national security and free speech, it is essential that the government's actions be transparent, accountable, and subject to judicial review. Visa revocations based on alleged support for terrorism should be based on credible evidence and due process, not on vague allegations or guilt by association. Moreover, universities have a role to play in educating students about their rights and responsibilities when it comes to free speech on campus. This includes fostering an environment where students feel comfortable expressing diverse viewpoints without fear of censorship or retribution. The cases of Srinivasan and Cordia underscore the unique vulnerabilities faced by international students in the United States, particularly when navigating the complexities of immigration law and the exercise of free speech. These students often arrive in a new country with different cultural norms and understandings of free speech, making them particularly susceptible to misinterpretations or mischaracterizations of their words or actions. The potential for political speech to derail their academic pursuits and jeopardize their immigration status highlights the need for greater sensitivity and support for this vulnerable population. Universities bear a responsibility to ensure that international students are aware of their rights and responsibilities under U.S. law, as well as the potential consequences of engaging in certain types of speech. This includes providing clear guidelines on what constitutes material support for terrorism and offering resources to students who may have concerns about their visa status. Moreover, universities should advocate for policies that protect the academic freedom of all students regardless of their national origin or political beliefs. The chilling effect of visa revocations based on protected speech extends beyond individual students, impacting the broader academic community. When students and faculty fear that expressing certain viewpoints could lead to government scrutiny or retaliation, it stifles the free exchange of ideas that is essential to a thriving academic environment. To safeguard academic freedom and protect the rights of all students, it is crucial to strike a balance between national security concerns and the principles of free speech. This requires a nuanced approach that considers the context of speech, the intent of the speaker, and the potential harm posed, rather than relying on broad generalizations or guilt by association. By fostering an environment of openness, understanding, and respect for diverse viewpoints, universities can help ensure that all students feel safe and supported in expressing their ideas and contributing to the intellectual vibrancy of the academic community.